This is Power 987 podcast. Now we're talking. Subscribe to Power 987 podcast on iTunes or wherever you get your podcasts. There's more on power987.co.za.
25 minutes to 2, Power Lunch on Power 98.7. Now we are talking. As well as do, in this slot, we talk about property, right? Renting a business premises is very different from renting a home. Whether you run a restaurant, a salon, a medical practice, office, retail store, or any other business for that matter, the relationship between you and your commercial landlord is governed largely by the lease agreement and the broader law of contract, and disputes can become extremely serious when rent is unpaid. The premises require repairs, the landlord wants to terminate the lease, or the business owner believes that the landlord is interfering with the business. I mean, there's a lot of things that can happen. Now, unlike residential tenants, commercial tenants are not protected by the Rental Housing Act or the Rental Housing Tribunal, which specifically deals with residential rental housing. So, what right does a business owner actually have? Can a landlord increase the rent whenever they want? Can they lock a business out for failing to pay? Who is responsible for the repairs and municipal charges? What happens upon the expiration of the lease? And what should a business owner look out for before signing a commercial lease? Quite a lot of questions. So today, we are putting commercial landlords versus business owners under the spotlight and unpacking what your rights are when you rent a business premise. As business owners, I'm sure you've dealt with this or you constantly deal with this kind of issues. Associate Attorney at SBL Inc., Alison Laxton, is on the line with us to help us with some of these issues. Remember, you can also give us a call, 0861 987 000, tweets at PowerFM987, or directly at Marara Moabelo. Your voice notes on 083 303 7093. Alison, good afternoon.
Hi, good afternoon, Quena, and hi to all your listeners. Thanks for having me on again.
Thank you for always making time. We truly appreciate that. So a commercial lease is not, as I said, the same as a residential lease. Tell us a little bit about that, what that means and what are the significant differences.
So I think the biggest thing to differentiate between is what you are using that property for and what it is zoned for. So if you are eating and sleeping and putting your head down on a pillow in a premises at night, it's probably a residential property, as opposed to a commercial property where you're trying to run a business. People aren't actually using that for residential purposes. They're not living there. And it's really important to make sure that you distinguish between the two, because a residential lease in our law is afforded a lot more legislative protection. So in South Africa, we have a fantastic piece of legislation called the Rental Housing Act, and the Consumer Protection Act will also apply to some extent to residential lease agreements. So when you rent a property that you want to stay in with your family, you are given a lot more protections, and that act specifically sets out what your landlord can and cannot do, how they can use your deposit, for example, how they must treat cancellations and rental escalations, for example. But a commercial lease in South Africa does not have a specific piece of legislation that actually governs the relationship between the parties. So given that everything is commercially and contractually sound, you have a lot of freedom in a commercial lease to draft up how the parties are going to interact between each other in that contract. And that is something that a lot of business owners wrongly assume when they enter into a commercial lease, is that they're going to have the same legislative protections as their residential property, and that is just not the case.
So does the nature of business, does one have to specifically state the nature of business that they want to use the premises for? Can I just say, leasing this, it's for business? Do I have to be specific?
I would always suggest to my clients and anyone who does enter into a commercial lease, please make sure that you specifically put what type of business is going to be running from that property. And this is going to come down to use and whether it's commercial or residential, and if that commercial use is actually something that can be carried out on that premises. So running a hairdresser is going to be very different to running a restaurant, for example, and there's going to be a lot of different requirements as to what the tenant and landlord need to do in that instance. So I would say it's not good enough just to say commercial. You want to make sure as a landlord that you know exactly what type of business your tenants are going to be running from that premises that you lease out to them.
And I mean the issues of I guess monthly rental escalation. At what point are those negotiated? At the signing or before the signing of the lease and agreement? Things like renewal, security deposit. Do they also have to be part of that discussion before one takes over the lease?
Definitely. So I always say to clients, remember in South African law, we have a principle called caveat subscriptor, which means he who signs undertakes that he knows and accepts those terms, right? So he who signs, beware, because the law is going to say, sorry for you if you say you didn't read the lease or understand the lease, you signed the lease, and therefore that's an indication that you agreed to be bound by all of those terms. So what you will find if you are engaging with a commercial landlord who really is above board and very ethical and transparent, they will send you all of the information beforehand, and they will be able to clearly and transparently break down what that lease is going to look like for you. So how many months is it going to be for? What is the renewal like? Do you have to give notice to renew? Is it an automatic renewal? Because a lot of people get stuck in leases because they don't realize the renewal is automatic. What are the escalations, and what does the additional charges look like? What are you paying for? Must you attend to maintenance of things like air conditioning, for example? So that is all really important to check before you sign a lease agreement, and it's a massive, massive red flag if a landlord cannot tell you up front what some of those costs and responsibilities are going to be. Now, of course, if you don't have a commercial lease in place and you are informally in this rental relationship, that's still okay because the courts look at your obligations and what was performance was tendered and accepted between the parties. But it's really, really good practice to make sure that you have a strong commercial lease agreement in place. With SBL, we recommend the TPN lease pack, and that's available to all landlords, and it's got all the clauses and documents that you need to make sure that you can run that commercial rental portfolio very transparently without many issues.
Can a landlord, for whatever reason, maybe rent is late and I'm not happy with whatever, can I just lock the premises up? And next thing, a person comes here, restaurant is closed, salon is closed, nail bar is closed. Can a landlord do that? And if so, under what circumstances?
So as your lawyer, I'm going to tell you a big no. No, please do not ever take the law into your own hands. The courts are going to view this with a very, very strict approach, okay? So if you are a landlord who is trying to evict a non-paying tenant or rental is late, there's been a breach of the lease in some way, you have to follow legal procedures to either evict that tenant or get them to perform their obligations, which means you need to either send a letter of demand to them, give them a time period that's reasonable to remedy, or you need to approach the courts and evict them with a court order. Okay, so we have seen cases where landlords will go and lock out their tenants. You are giving your tenant a one-way ticket to claim damages from you in court, and the likelihood is they will probably win because you have taken the possession out of their hands, unlawfully so, and you've committed what we call in law spoliation. So a very, very risky thing to do as a landlord. As frustrating as it can be, please avoid this and consult a property attorney when you can see that a tenant is going to give you problems.
0861 987 000, tweets at PowerFM987 or directly at Marara Moabele in conversation with Alison Laxton, Associate Attorney at SBL Inc. We are talking about commercial landlords versus business owners. What are your rights when you rent a business premise? Now, when it comes to issues of rent increase and escalation clauses, once the business is on, when do they come into play? If, for instance, we've agreed on everything else and I start my business, I have my nail bar, I have my salon or whatever it is that I'm doing in that premises, is it also, is there a clause that clarifies that ahead, or can a landlord come 2 years into this and say, well, Ramaphosa's economy, I'm going to have to take your rent up?
Yeah, and that's one of the most contentious issues. So remember, in a commercial lease specifically, we are looking at the agreement between the parties because there is so much freedom to contract and there's not necessarily a statutory or legislative protection. Now, in a residential lease, the wonderful thing is, I see it all the time with people in Cape Town, right? The landlord gets greedy, they come along and they say, your residential home, the rent is going to go up by 30%. And you can't understand how that's a reasonable increase. As a tenant in a residential space, you have protections like the Rental Housing Tribunal that you can approach free of charge, and they will help to mediate that dispute and make sure that your increases are reasonable. Now, the problem with a commercial lease is unless you can prove that it is in bad faith or extremely controversial, against public morals to an extent to increase the rental, you are going to be relying on what you've contractually signed. So what is important to note is commercial leases are often for a few years and they're not just short term. So 5 to 10 years in some instances. Now, it's important to ask your landlord before you even get into that lease, what are your increases going to look like? And if you're not happy with accepting an increase, how do you then get out of that lease? What are the notice periods? And are there any penalties that may apply? They'll follow general rules like 10 to 15% per annum, or they'll try and match inflation. But what is important is to really try and get something in writing. And if you know you don't have that in your commercial lease, please try and get your landlord to pin it down and give you an addendum that discusses how these increases are going to be handled.
A message on WhatsApp says, can a landlord discriminate against tenants as far as how much rent can be paid? One runs a hair salon, pays 2,000 a month. The B runs a dry cleaner, pays 1,000 a month. Assume they occupy the same space. So basically saying that if you're occupying the same space, can the landlord say, Alison, you are paying 2,000 and I'm paying 1,500, even though we're in the same space, same area?
Yes, unfortunately they can, and that is up to the landlord to have their own commercial flexibility as to what they want to charge per square meter for that rental property. So you will often find that this is where the art of negotiation comes in. If you are trying to move into a premises, try and do your research and find out what is not only the center occupancy rate like, do they have enough tenants, or are they going to pass that cost on to you, but also try and find out more or less what is everybody else paying for a similar size shop. And what is the area rental like as well? Don't just look at one landlord in one area. Try to look around and see where you can find the best deal. Now, also, if you're committing for a long time, try to say to the landlord, can we agree on some sort of discount or a rental freeze? There are plenty of commercial landlords now with empty space since COVID who are happy to give you discounts and rental freezes. So I say if you're a good negotiator, then go for it. You can definitely make sure that you get a good deal. So perhaps the dry cleaner was a better negotiator than the hairdresser in that case.
So it doesn't depend on business and turnover and all those things. If somebody says, well, the dry cleaner is making more money than the salon, so you have to pay me more.
Yes, and remember, the landlord, a commercial landlord, is not going to be worried about whether your business is successful or doing well. They worry at the end of the month if they get their rental or not, and that's as far as the business support may go. So it's not up to how successful your business is. I always say negotiate, negotiate, negotiate.
So a landlord can't come to me and say that we agreed on R1,000 rent, but your restaurant is doing so well, I'm raising the rent.
Not unless there's clauses to that effect.
Okay.
I would definitely challenge them and say, show me in the lease where it says you can do that.
When it comes, I mean, especially when you do business, there's improvements in the space, right? Whose responsibility is that? What happens to improvements made by business in that regard? Is it still on the business owner or the landlord, or there has to be an agreement as to what sort of improvements can you make to the property?
So I think this is something that's very important to discuss with the landlord before you even do any improvements. The first point of call is obviously to consult your lease agreement, right? Because a lot of tenants feel entitled to be reimbursed in some way, or like they should receive some sort of discount on the rental if they do improvements. Now, unless your lease specifically states that you're going to be entitled to this, you are going to lose out if you do improvements to a property that is rented. A lot of the improvements are going to accede to the property, which means it becomes part of the property, and you may not be able to remove those, especially if they are permanent and not just removable fixtures, okay? So that is an important thing to discuss with your landlord before you even do it. And if you're going to spend a significant amount of money doing such improvements to maybe bring in more business or make the premises more attractive, that's when I would go back and say, negotiate once again and see if you can get a rental remission or some sort of compensation, because it's going to benefit the landlord as well. Maybe there will be increased foot traffic or more customers coming into the center. So that's where you need to make sure you have it cut and paste in writing with the landlord as to how you are going to handle improvements. Because unfortunately, it's not an automatic thing that you are going to be reimbursed for it at all.
I think this one deals more with residential accommodation, but I want to ask the message, though, that we got on WhatsApp. Can a property rental agent instruct the caretaker to deny access to tenants by removing biometrics access for late payments?
Oh, we see this all the time.
Oh, does
where
it?
people get creative with how to help themselves. They see what the lawyers charge for evictions and they think it's cheaper to do it themselves. Unfortunately, that constitutes self-help. And if you are still a tenant for the purposes of staying in a complex, you still have a lease agreement, even if you haven't paid your rental, right? You then are entitled to still access the property. So until they get a court order to lawfully evict you or you agree to vacate the premises, then they cannot cut off biometric access. Please, I urge people who are in this situation to either approach the Rental Housing Tribunal or to approach an attorney for assistance to allow you to be given that possession of the property back. It's something we've seen so much in complexes where body corporates are getting very creative. So they've stopped turning off the water and electricity. Now they take away your biometric access, for example.
I want to go back to, and I'm looking at the time, Alison, I want to go back to the issue of improvements in the property. Once the lease ends, who owns those improvements? I paid for them as a business owner. The lease ends, and what happens?
So it depends on whether you've done an improvement that's a fixture or a permanent installation.
I see.
Okay, so your permanent installations are probably going to become property of the landlord. And what is important to note is that fixtures, you should be able to remove them. Okay, so if you're going to do significant improvements, my advice to tenants is try to do something where it is easily removable and isn't going to accede to the property. So it's not going to become part of the landlord's premises. Now, what is important to note, and speak to your landlord before you even get into a lease, is what happens when I have to leave this premises. Is there going to be a charge passed on to me, or must I be required to white box this premises, which means you restore it to the original condition, right? So it's very important to clarify, can you remove your improvements? Must I pay any compensation, or must I receive any compensation? And also get your landlord's consent before doing renovations. A lot of times tenants say, but I'm entitled to compensation, I did all these improvements, and they never got the landlord's consent. And that's going to leave you with empty pockets.
So, commercial disputes can naturally, Alison, become extremely expensive. So in a situation where a dispute between a landlord and a business owner is not simply just about rent, it could be a disagreement, maybe threaten the entire operation of the business. And if a business loses access to its premises, what happens?
And that's the important thing to note. And I always say, please, there's so many great attorneys out there. We're one of many. If you are going to enter into a commercial lease, and especially if you're a tenant, just pay an attorney a couple thousand or a couple $100 to review what you are going to sign. I cannot, emphasize the importance of checking something before you sign it. Please do not ask ChatGPT and AI. It can be a useful guide, but we are seeing clients relying on AI for agreements, and it's falling short. So I always suggest, if you're going to sign a lease and you are a tenant and you can see that this is a 5-year commercial lease, just get a lawyer to assist you with queries and questions and possible changes. And remember, you can negotiate until things are signed. So use that to negotiate. The commercial spaces at the moment are not as occupied as they were before COVID. We're still seeing empty premises with landlords who want to attract tenants, and that's going to give you a power advantage here. So if you are already in a lease and now you're thinking, how do I remedy this? We are seeing a trend in our high courts where they are enforcing mandatory mediation before you go to trial. And so what's important is have a look in your lease agreement. Are there dispute resolution clauses? And you may be entitled to then approach a qualified mediator who can sit the parties down as a third party and try and find a solution. Otherwise, if you just aren't winning, it may be time to seek legal advice.
And I mean, so naturally, one has to make sure that they know what they are signing, right? So what are some of the biggest red flags in commercial leases and when a business owner should get legal advice?
I think some of the biggest red flags are when you feel rushed to sign a commercial lease and they aren't transparent with what everything means, okay? So not all of us are legally trained and can understand these complex leases. So you should be getting a breakdown from a commercial landlord as to how this lease is going to work in practice. You don't want to get bogged down with all of these confusing, lengthy paragraphs in a lease. So anything that is vague, a vague escalation formula, or operating costs that don't seem to be capped, if there's harsh clauses that really favor the landlord and don't give you any room to negotiate or get out of a tricky situation, those are all red flags. Remember, in a commercial lease, there's also the option for a landlord to request that a tenant attends to certain repairs that usually they would do. And something like air conditioning, you don't think about it, but that's a very expensive thing to fix if that's on you as the tenant. Renewal clauses that are vague or are automatic and don't say how you can get out of a lease, that's also very, very dangerous because you're now opening yourself up to the court's interpretation and what they will deem reasonable damages. And if you're in a 5-year lease and you want to get out by year 2, you may be liable for the rest of those 3 years. And that's a huge financial commitment and could be the end of your business.
Alison, we're going to have to leave it there. Thank you so much for always coming through to speak to us and for your insight. Just for people that want to find out more about you, maybe take the conversation further, where do they find you?
Thank you, Quena. You can find us at sbllaw.co.za.
Alison Laxton, Associate Attorney at SBL Inc. And again, know what you're getting yourself into. And I think for me, that is always the big lesson when it comes to issues of rental, be it business or anything else. Know what you're getting yourself into. Read the fine print. Make sure you understand. If you don't know, ask somebody who can. And so that they help you out. They look at the fine print and they see. Because the next thing, your biometrics are disabled. You are unable to access the premises. But also, if your rent is late, my guy, what are you expecting? If your rent is late, what are you expecting?
You've been listening to Power 987 Podcast. For more podcasts, visit power987.co.za or subscribe wherever you get your podcasts.